Now, the next and the last speaker is Georg Borges. Of course, I assume Mr. Hofer has the same background, and I'm a lawyer as well. But I assume that all the participants are really interested in liability and new technologies, which is, in my view, one of very, very important questions, because technology is very innovative, and liability does not cover a specific product or part, and so far I believe that we will have more and more court decisions on that. But for me, I'm really happy to introduce you, Mr. Borges. I would be thankful if you could introduce yourself. I believe you can do that better than me, but I'm happy to hand over to you in order to start with your presentation. Thank you.
You will have to switch on your microphone, Mr. Borges.
Yeah, is it better now? Yes. Thank you for that advice. Yeah, I'm very grateful for this invitation, and it's my privilege to talk about aspects of civil liability and new technologies. I'm a professor of law. I'm the managing director of the Institute of Legal Informatics at Saarland University. My field of research is for more than 20 years, IT and law. I have practiced as an attorney before becoming a professor, and also, besides being professor, have served as a judge at one of our regional courts of appeals. Today, I'm managing director of the Institute of Legal Informatics, and I would like to give a few information about this institute. In our research, we cover almost any field of IT-related law and also technology, as in our institute we do not only have several chairs of law, we are also proud of having one professor with a full chair of informatics within the institute, and also the faculty of law, which is rather unique in Germany. Besides research, we are heavily involved in education. We have a very new postgraduate degree, IT and Law, and LLM master course, but also within this, within the studying, we have a focus area, IT law and legal informatics, and other events like seminars and so on, and also including services for the public, which might be interesting for you, just maybe our Jura Push or BGH Push information service. Please just visit our website. I mentioned the master's program IT and Law, which we started this academic year. The reason why I refer to it here is that it is truly interdisciplinary. We receive students with a legal background as well as with a background in engineering or informatics. And something for everybody of you, which might be interesting, our international summer school, which will take place even though we had difficulties and had to wait long for final decision. Finally, we will not give up. It's not cancelled. Will take place in Saarland this summer. In today's agenda, liability and new technologies. By way of introduction, I would like to pose the question if liability can be a response to specific risks of emerging technologies. You know well about emerging technologies, and here you're mostly interested in new technologies in the medical field. Besides surgery robots or care robots, there are many fields where new technologies come in. For diagnose, AI is already in the field and widely used. However, besides the opportunities that new technologies offers, there are also some risks. One of them is damage. Technology can cause damage, and not the example of medical AI, but the example of autonomous cars is puts a focus on this risk, and that's why, from a legal perspective, we have to ask ourselves how our legal system can cope with that. There has been a European-wide or even global debate on the regulation of robotics and of AI. And one of the most important aspects, triggering points of this discussion was the European Parliament's resolution of 2017 regarding civil law rules on robotics. The European Commission answered 1 year later with in its communication AI for Europe. What I found particularly interesting in this communication is that it is, whilst of course focusing on the opportunities and on industrial matters, it also developed quite a large room for legal aspects, among them liability. So if you go back to that communication, you'll find 4 of 17 pages regarding liability. And this spring, the discussion really is in full speed. One important, I don't know if it was important paper, but one paper which was published end of last year, November 2019, which you might be interested in, is the expert groups on liability and new technologies report, Liability for Artificial Intelligence. I will come to it in a minute. This February, we had a report by the European Commission on safety and liability of AI, and quite recently, I'm still going on and in the parliamentary proceedings has been published a draft report of the European Parliament, more precisely the Committee on Legal Affairs. This report is in an early stage, of course. The European Parliament will deal with it over the summer and might publish it finally at the end of this year, which would mean that the European Commission would have to respond within 3 months. I would like to attract your attention to the report Liability for Artificial Intelligence by the expert group Liability and New Technologies. I was a member in this expert group. We were about 18 professors from all European, mainly all European countries. We worked together for almost 1.5 years before we finally published our report. I'm very proud to see that the European Commission as well as the European Parliament is making some proposals which are very near to what we suggested in this report. For the ongoing legal debate, of course, the draft report on the European Parliament's Committee on Legal Affairs is of particular interest. You will find it on the internet. And what is particularly interesting is that the committee goes as far as to suggesting the enactment of a regulation on AI. So it's a European-wide law for the operation of, for the liability for the operation of AI. So that comes pretty close to everybody's daily practice if it would be enacted. Why all this? What is the goal of the current debate on liability for AI? The first and most important aspect, of course, is compensation for victims. In our expert group in Europe, we discussed it, and we were never as unanimous as in this answer that we think that the risk arising out of the use of new technologies should not be borne by the victim. Obviously, any technology can cause harm, and no technology can take harm out of this world. However, if technology is causing damage, we think that compensation for damages should be guaranteed in order to at least financially compensate the victim for damage suffered. When we talk about compensation from a legal perspective, we have different possibilities. One is liability, but also, and in particular mentioned by the European Parliament's resolution of 2017, another model is compensation funds. Where we talk about liability in first place, we have to distinguish several kinds of liability. And I just want to briefly mention the main principles or concepts I would like to use the word of concept of liability. The traditional one, which we know in tort law for hundreds of years, is fault-based liability. Someone is liable if he or she negligently or intentionally caused the damage to someone else. Besides that, we have strict liability, and there I would like to make a distinction. I would like to distinguish the strict liability in a broader sense, which we find in product liability, for instance. Here we have, besides the causation of a damage, the requirement of an additional aspect, like in the case of product liability, the defect of the good. We also have a stricter form of strict liability, and that's why I'd call it objective liability. That's also the term which we used in the expert group. Objective liability is a form of liability where any damage caused within the defined sphere of risk has to be compensated. We do find this objective liability in several areas, for instance, in the case of the operation of a car, where the registered keeper of a car is obliged to compensate the victim for any damage caused. A totally or possibly different concept of compensation are compensation funds. We do have compensation funds filling gaps when liable parties cannot compensate. For instance, in the field of car accidents, by current law, we have such compensation funds. What we do not have at this moment, but was asked by the European Parliament in 2017, if there should be compensation funds replacing liability in the case of AI, given that existing legislation cannot fully guarantee compensation for damage caused by AI. And why is it so? I would like to go into this. Just as a first conclusion which we drew in the expert group, we did not think that compensation funds replacing liability seemed to be a good idea. Instead, we hope to develop the existing liability regime. And in the following, I would just draw your attention to some of the aspects for it. When we talk about liability, we should distinguish the parties and roles involved. In case of the liability for AI, we have the producer, the operator, the seller, which I would not take into account in the following, and the user, for instance, the driver of the car. I would like to focus on the roles of producer and operator, which are also in the focus of the current discussion. Regarding the liability of the operator, the thesis which I support and we also found in the expert group was that the operator should be liable to compensate the victim for some simple reasons. The operator benefits from the use of the technology, and the operator is often best in place to control the risks arising of that technology. Also, for practical reasons, the operator is often to be easier to be addressed by the victim. That's why the expert group, Liability on New Technology, suggests to introduce strict liability of the operator. When we go into details, I would like to explain what it means by the example of liability for autonomous cars. There also, we have those 4 rules. The operator, in this case, is the registered keeper of such car. We also have the driver, the manufacturer, and not to be forgotten, the insurer. According to German law, which you probably are well aware of, we have a strict liability according to Section 7 of the German Road Traffic Act, which is a strict liability in a narrow sense, which I would call objective liability. Besides that, the law also provides liability of the driver according to Section 18. However, this is of little practical relevance for a reason I will show in a minute. What is important in the case of road traffic is that we have, in Germany at least, a scheme of compulsory insurance. According to the Compulsory Insurance Act, any registered keeper of a car, which you well know, has the duty to maintain compulsory insurance. And what is more important in our context here is that we also have a direct claim of the victim against the insurer, and which most people do not know, according to the same law, the Insurance Contracts Act, there is a sole liability of the insurer in the internal relationship. So under current law regarding road accidents, it is always the insurer who should pay and compensate in the end. This is very important to keep in mind, I think. So as an interim conclusion, I can say that the focus of liability in case of road accidents is on the registered keeper combined with a system of compulsory insurance, which leads to the insurer to compensate. Now, we are here in a medical context, so the liability rules for road accidents are not obviously not applicable. So what is the question about liability for autonomous systems in general? As so far, we do not have a specific liability regime for medical AI systems. Well, autonomous systems is a wide range. This here you find an autonomous lawnmower, but there is not so much AI, if at all, in this lovely machine. And also it doesn't seem so pretty dangerous, but some of you might know that even such innocent machine already was able to produce harm. There's one case reported in Germany where such lawnmower cut a small kid's feet heavily and caused damage here. But we have more dangerous than this. I would like to present some very traditional autonomous systems with a much higher damage potential. What you see is two pictures of an animal, and you might ask yourself, what is he talking about? Why do I call the animal as an autonomous system? For the simple reason that, of course, these are animals, not machines. But what they have in common with potential AI is the unforeseeability and the autonomy of behavior. And that's what we exactly talk about when we talk about modern technology using AI, in particular machine learning technologies, that we reach in these machines a certain degree of autonomy, which is steering behavior. And this is the aspect which is in the core of the discussion. We have an autonomy acting system called machine, which has a certain degree of autonomy in that way that it cannot easily predict it. What the exact behavior of that machine in a given situation will be, particularly if that situation is unusual, not practiced before. Why am I, as a lawyer, referring to animal when we talk about AI? I think the lawyers among you might know already there is an interesting provision in the German Civil Code regarding animals, and which reads liability of animal keeper, the famous section 833 of the German Civil Code, introduces a strict liability of the keeper of an animal, which would be the operator of an animal. And we read that if a human being is killed by an animal, then the keeper has to compensate. Interestingly, this section does make a distinction between liability for domestic animals intended to serve the keepers in economic activity and other animals. So as an interim conclusion, to cut it short, this section cannot be transferred easily one-to-one to the liability scheme for AI. However, it makes it clear that already 100 years ago, the legislator was aware of the specific risks of autonomously acting systems and introduced strict liability as a response to this. So if you come back to the original question, we can see that within the law, the idea of introducing strict liability in case of specific risk of autonomously acting entities is a tool which is in our toolbox. Now, from 100 years ago to the future, let's have a closer look to the proposed regulation on liability for the operation of our AI. This chapter 2, the article 4, is a chapter which is suggested, as I mentioned it in my introduction, by the European Parliament's Committee on Legal Affairs. What is their idea? I read paragraph 1, the deployer, which is the same as an operator. So the deployer or operator of a high-risk AI system shall be strictly liable for any harm caused by a device driven, that is, by an AI system. So to cut it short, the European Parliament suggests strict liability for high-risk AI systems. And that liability, the addressee of that liability is the operator. You will ask yourselves probably what is in the case of other AI systems, and here the principle is laid down in Article 8. The deployer of an AI system that is not defined as a high-risk AI system shall be subject to liability on the basis of fault, since in section 2 we find the excuse the deployer shall not be liable if he can prove that the harm or damage was caused without the fault. So to summarize, the idea of European Parliament's Committee for Legal Affairs is that we introduce a strict liability for so-called high-risk AI and fault-based liability for any other AI systems. And that liability, coming back to the main idea, who is the addressee of liability, should be on the deployer or operator on the system. Now, focusing as the European Parliament's draft does to the responsibility of the operator, we should ask about the responsibility of the producer. In a medical context, if you take, for instance, the idea of a surgery robot, it would be a hospital who would be the operator of the robot, but possibly the hospital is not aware of the technology as such, since that has been delivered by a producer. So by a legal framework perspective, the question always is, what about the responsibility of the producer? And I would like to go into this a bit more detailed. In that case, we have to distinguish traditional forms of liability, in particular product liability and producer's liability. Producer's liability or manufacturer liability, the German term of which is Produzentenhaftung, has as a legal base in traditional tort law, section 823 of the German Civil Code, is the legislative basis for this liability. Here, to cut it short, the requirements for liability are a breach of a duty of care and causation, both to be established and proven by the victim. For these reasons, you can imagine the victim, let's say a patient who suffered from some kind of mistake by a surgery robot, will not be easily able to demonstrate the fault by the producer, since he or she does not have any information about the functioning of the robot. So manufacturer's liability tort law is weak here. What about product liability law? You might know that we have a European-wide product liability law based on the Product Liability Directive, and in Germany transferred to national law by in the Product Liability Act. Here, as I mentioned it earlier, we do have a strict liability provision. However, it's not objective liability. It is strict liability in a broader sense, for the simple reason that the liability requires there to be a defect as the cause of the damage. And that defect and the causal link between defect of the product and the harm occurred has to be demonstrated and proven by the victim. For that reason, in practice, the liability under the Product Liability Act is quite similar to the liability under tort law, which is, as I already mentioned, rather weak. That's why the question arises, is that enough to cope with the risks of AI? I would like to ask for some minutes, if I still have time. I look to the organizers. Do I still have 5 minutes to go on with my presentation? Thank you very much. What about product liability and AI? One interesting question, which is still not solved at all at this moment, goes to the question, what is a defect in a case of an autonomous system? And let me put it as you can read it on the slides. The question is an individual occurrence of defective behavior in itself a defect of the product which generated such defective behavior? Just to give an everyday example, I may violate speed limits. So my behavior is defective, you won't so, but as a person and driver, I'm not defective as such. You would not, in the case of a human's behavior, derive from a single mistake in a specific behavior, conclude that this person is defective. Can you do so in the case of a machine? But in particular, if the machine is trained to react autonomously and differently in different situations. This question is completely open. We find all and any positions in literature from yes, any defective behavior constitutes a defect to no, defect is something totally different from defective behavior, as to if it's in general no less mistaken than a human, it's not a defect, and so on. But just to keep in mind, this is open question, so in practice, not easy to take. And also, it has to be questioned, what is about AI which requires monitoring and updating usually? Most AI, in particular if based on machine learning technology, is done in a training process, and of course the training process does not have to be stopped after deploying or bringing the product into market. Indeed, we would see that updating and continuous learning, not for the single product of course, but for the product as a product line, is essential. And the question is, how can we guarantee that our products are equipped with the latest and best version? So the question of updating of systems is a very important question. Another question is, what about technical improvement? Consider that you bought a very expensive surgery robot, to keep with the example, and 2 years later, a new version of that robot will appear on the market with a much higher degree of safety. Can you then say product liability is based on a defect at the time the product, the specific particular product was brought to the market, so 2 years ago, or is there any claim or right to bring in the newer and more safer software on the surgery robot? This is not at all covered by the product liability law, which focuses on the existence of a defect at the time the specific product was brought into the market. So the question of the dynamic of technology development is not addressed by existing legislation at all. For that reason, the expert group addressed that aspect and asked the legislator to introduce a duty of care among those monitoring, maintaining the system, even after putting it into circulation. Last but not least, in 2 minutes, some new approaches which go a bit beyond the traditional system of product liability. The question is, how can we address producers by tort or by liability, for the simple reason that liability rules can incentivize the producer to provide safe products and services. The challenge is that, as the example of a autonomous car as well as the example of a surgery robot, I think clearly demonstrates that the operator, so the owner of a car or the hospital which is using such robot, is not necessarily best in place to control the risks of such machine. Instead, very often the producer have more insights and more capacity to control the risks. So why not addressing the producers? One approach to aiming at this is a proposal in literature, which myself support. Would be the introduction of objective liability for the manufacturers of self-driving cars, or in other cases as well. The reasoning for this proposal is that in some cases, and certainly in the case of autonomous cars, the manufacturer are best in place to control the risk. In such case, so if such liability would be introduced, of course, it would not replace the existing liability of the registered keeper. You would have a system of joint and several liability of both keeper and producer, and the internal settlement between the keeper and manufacturer would be done via the insurance, actually. I skip a few slides and come for the last minute of my presentation to an idea brought up by the expert group in its final report, and that is the idea of a second operator. Very interesting, we had the idea in the expert group to distinguish between a front-end operator and a back-end operator, and this is new. Never ever such idea has existed in current legislation so far, and but the idea is was interesting to us. We found it convincing. Why? Because we see that we still have a person who is primarily deciding on the use and benefiting from the use of the tool, for instance, autonomous car. However, we see that another person, by continuously defining the feature of the technology, by giving backend support, and lastly, controlling the risk, is also to be identified, and that person we call backend operator. In case of autonomous cars, the manufacturer of a car would certainly qualify as such backend operator, and the same might apply in the case of the producers of medical AI systems. So as a conclusion, in my view, and also in the view of the expert group, Liability and New Technology, as well, obviously, in the opinion of the European Commission and the European Parliament, the existing liability system contains gaps and has to be developed further, and a new system of liability should be introduced in order to guarantee compensation for victims. And one element of this new scheme should be strict liability, maybe even objective liability. And it seems that in general, operators of autonomous systems, at least in the case of high-risk AI systems, should be liable. In my view, this is my personal opinion, the producer should also be addressed, at least in some cases. Objective liability should also be addressing the producer. And certainly, and here unanimously in the expert group, we decided that we need to introduce duties to adequately train and monitor autonomous systems based on machine learning. And that should also be clearly defined and stated in the law. That's it. Thank you very much.
Thank you very much. So so you did not participate in our last summer academies, but we discussed in the last summer academy the question, how is liability, or can it be linked with AI? And I was aware that some papers have been published now. I'm not so trained in these liability questions. However, I can agree, but it is also a question to you, for patients with regard to medical devices and AI, which will be more and more used in, for example, in connection with surgeries. And we heard it today from Brain Lab, what they plan for the future. The patient is not aware what is going on in the background. During the surgery, the patient does not know which products will be used, what is the navigation system, is robotics used here. So the patients do not have any clue, and I think and I believe patient protection is very important, and it's absolutely clear for me to reach out to the operator, because as you said, this is a direct contact, and also on a contractual basis, the direct contact for the patient. However, I find this idea very interesting to differentiate between the front operator and the back-end operator. For me, it feels somehow unfair that always the front-end operator, the medical institution or the physician, should be liable vis-a-vis the patient without any influence on the AI system and the development. And so far, this is one of the most important problems I see here. But that's something I saw it the first time today, the back-end and front-end operator, but that's, I think, theory which we could follow here. So you said it's a publication currently, but not part of the European discussions?
Yes, this distinction between front and back-end operator was created, as we saw in the expert group, that suggesting liability of the producer, as I did in my publication, will not be successful in the political process. Mm-hmm. That's why the distinction between backend operator, which in many cases can be the producer or the importer or whatsoever, is a tool to introduce a solution which might be doable, which might survive the political process. To my big regret, the committee's European Parliament Committee of Legal Affairs draft of April does not mention it and did not pick up this idea. So I am in contact with the rapporteur and will, I hope I can bring the benefits of this idea to him. But I'm a bit skeptical if the politicians will pick it up. In my view, it is very important to address the producer as well, since the operator may be a smaller or bigger hospital, but they're just the customer they're just the user of a tool. They don't fully understand themselves. How should they? And so the entity controlling the risk is the producer, be it autonomous car, be it a surgery robot or some other AI equipment. Our doctors and also the managing directors of a hospital are not in place to control this risk. They can rely in certifications, and they can gain personal experience in the use of such technology, certainly, but they're not the ones to judge the risk of this. So that should be done at another stage. And liability is a very subtle incentive for maintaining safety. That's why myself and also the expert group as a whole supports the idea of addressing those persons who are best in place to control risk by liability.
Okay, thank you. I see that we have a question in the chat somewhere.
Can I see it myself?
That is a very long question.
Okay.
Jan Nordmans, do you have a microphone? Can you switch it on and maybe talk to us?
Yes, I can talk to you. I'm Jan. I'm working in the Netherlands in a hospital, University Hospital in Utrecht.
Welcome.
And I describe a case where a medical device failed in our opinion, but we had trouble in proving that the fault was with the medical device and by the manufacturer. I described the case there. It's I always have, just because I'm talking to people who have a juridical background, how can we be helped as a hospital? Can we claim the manufacturer for this fault? You only have one case in 10,000 surgeries, and often the other malfunction occurs in our hospital. It's maybe you can share some thoughts about such faults.
Yeah, that's exactly the case why product liability is not as strong as a remedy as you might think. Proving the defect of a product is not an easy thing at all, where the hospital does not have any information about the details of the product itself. You just receive it as an end user, and you don't have any insight as a hospital. So in Germany, that is important to know. I didn't mention it in my presentation, so thank you very much for this question. The main issue is the burden of proof, actually. Mm-hmm. Under German law, in the German proceeding, the claimant has to prove all the requirements for liability. So the victim or the hospital, if the hospital doesn't have a claim, by the way, under product liability, doesn't make it easier. In the case of hospital, asking for compensation is only the contract. So the purchase contract or another contract on which base the tool was delivered, actually. But let's assume that we have a patient who is victim who wants to make a claim against the producer. Here we would have the question that the victim doesn't have any possibility to prove the defect. And the idea to introduce strict liability in the relationship between on the manufacturer would make it much easier in a court claim to prove the requirements of liability, since there's not that much. There's only the causing of a harm to a patient, and that would be easy to prove for the patient. In that case, this liability would be very strict and strong. That's also one aspect, which is the reason why industry doesn't like strict liability in the meaning of objective liability. So in your case, the procedural law, the burden of proof is a real issue. Current German law does not help. I would like to mention that the expert group suggests a reversal of burden of proof in certain cases, which might be applicable here.
Okay, thank you. We're looking forward to the future.
Okay, do we have another question? Another person in the chat?
Okay, check the chat again.
I can read this question to everybody. Regarding the concept of back-end and front-end operator, is the concept of the producer, the system architect, distinct from the concept of the back-end operator, who, for example, selects the data sets used to train the AI, but does not design the system itself?
Yeah, that's a very good question. Very good question. The concept of a backend operator does not clearly describe who the backend operator really is. So it's just a first step. If you want to go into this idea, we would have to find out criteria to distinguish the backend operator. In the example, in the questions, probably the person training the AI would be backend operator rather than the one who made the initial architecture or concept. That question refers to another interesting question, which related to machine learning. We have to ask ourselves, what is the role of the person doing the training? In my view, that person has to be regarded as a producer and would be subject to product liability, at least. However, it's also hard to prove a mistake in training, actually.
Okay.
So giving clear answer to the question, there is no clear answer at this moment, since the concept has to be better defined. It's just an idea at this moment. It's not existing law at this moment.
But that leads me to my question. So if we have a lot of ideas how to deal with liability, especially with regard to AI, what do you believe, or do you have any knowledge how courts would coordinate or decide maybe the cases? Is there an existing case in Germany, and we only have product liability and our court decisions. Before we have any directive or a specific law in place, what would courts do currently? Because I see a lot of problems in the interpretation of the elements of those sections.
That's a very broad question. It's hard to answer to it, but I will try to give a few comments. At this moment, it is hard to see what you can expect from product liability. I try to find judgments on regarding product liability for software or IT systems, but you don't find it. In Germany, we don't have published judgments. There's 2 or 3 regarding IT. Why is it so? Because this a claim based on a product defect is really hard to prove. So in practice, we do have claims based on product liability. Most of them are settled or just dismissed, but we don't have much there. 90% it seems is settled, and actually it's rarely used. And the big bunch of case law regarding product liability is based on instruction. So yes, there are cases based on product liability, but 80 or 90% is instruction mistakes. No court goes into the details of technology. This is for good reason. They're not experts there. And that's why product liability is particularly weak when it's with regard to complex technology. For that reason, we need objective liability in those cases.
So, my experience is that when I focus on medical devices, very often the court decisions or the product defects are somehow hidden and combined with medical malpractice. So it's very often not the product as such which plays a role in these court procedures. It's at first instance, it's the medical malpractice, because it seems to be medical malpractice for the patient. But in the background, I have the impression that very often this is also linked, not only, but also linked with product defects. And so maybe it's not the question to only look into product liability. It's also a question of medical malpractice, which then leads us again to the operator.
When we go to medical malpractice, usually we talk about a contractual claim. Right. So in the patient will address the hospital based on contracts, and usually should have an easy game if there's some damage or some harm which cannot be explained. And then the hospital's insurers would join in and compensate. And the question which we have to address from a regulatory perspective rather is not sending the patients to address the producer. That's not the idea. The idea is that the insurers can address the producers, and by this incentivizing them to invest more in the safety of products.
Yes.
Because it doesn't help anybody if the insurance charges high fees to hospitals to compensate to alone compensate the victims. If you don't address the producers, there's no incentive by liability to invest in the safety of products. And this is my biggest concern, that our current legislative system increases the cost of medical treatment by insurance costs, but does not address the one who is in the position to produce better safety. And the more autonomous and the more sophisticated AI-based technology in the medical sector will be, the more important that problem will be in practice as well. That's my concern. That's why we suggest in the expert group the introduction of strict liability, and myself vote for the introduction of strict liability of the producer.
Okay, I agree. So I'll look as to whether there's another question. So in the chat, I don't see any questions. Oh, there's a question from Ms. Heinz, a colleague.
Yes, hello. Thank you, Professor Borges, for your interesting presentation. I have one additional question concerning the medical device regulation, which at least mentions liability now in its Article 10 under the general obligations of the manufacturer. So for me, this is at least one hint that the producer or manufacturer has been taken into account, even if it's only mainly a reference to product liability directive and the obligation to, how is it defined there, to have measures in place to provide for financial coverage. How would you understand this new regulation in the context of what you have presented before?
It does exactly not offer that solution which I suggest. Instead, it's not stuck, but it relates to the current liability system in the light of product liability, which is rather weak, as I explained it. So yes, I might have mentioned in my presentation. Thank you for that additional question, which is a very good one. To my understanding, we do not find this new element here unfortunately.
Thank you very much.
So any further questions?
I have a question, Dirk Hermsmeyer from the Chamber of Commerce in Lübeck. Professor Borges, thank you very much for this presentation. I liked it very much, especially the comparison of animals and AI systems as both being autonomous. That's very enlightening, I think, that comparison. I remember 2 or maybe it was 3 years ago in the same conference, Lübeck Summer Academy, we had a presentation by a colleague of yours, a lawyer at the professor of law at the University of Hanover. And unfortunately, I don't remember her name, but she suggested, in view of AI systems, maybe there could be a need for introducing a new legal entity for such products, in addition to natural persons and corporate organizations. Now that maybe there should be a new legal entity. Now, since then, probably the discussion has evolved over the last 2-3 years. But my question is, was this concept discussed in the expert group or in the commission or in the parliament? And if so, why was it rejected, apparently? Because it didn't play a role in your presentation today.
If you want to hear more of the of the e-person concept, I recommend my summer school, where I will present on this in more detail. But thank you very much for this highly interesting question. The e-person concept was in the discussion mainly after the European Parliament's resolution of 2017, which explicitly mentioned that idea. Since then, we had an intensive discussion globally on this idea. I can say that the majority of law experts, at least in Europe as well as in the Anglo-Saxon world, rejects the idea. Also, the expert group was not rejects the idea, thinking that this concept is not needed at this moment. In East Asia, particularly in Japan, where I also have some contacts, there's much more sympathy for that idea. However, I can say the legislator, the European Parliament, as well as the European Commission at this moment do not favor the idea of going into this direction. I personally think e-person is not an idea for now, and it's particularly not an instrument to address liability, actually. For one reason, if you want to make the system liable as such, the system has to have a fund. That's why compensation funds was also mentioned. But then there is someone to feed the compensation fund, and also we need rules to pay out from the compensation funds. And what in the end would it do? It would do that we have a strict a kind of liability scheme based on a single individual system, let's say one car, one robot, equipped with a kind of fund, which is just an insurance in the end. So the question is, if you just want to introduce e-personhood as a tool for liability, it doesn't add anything in my view. And if you establish e-personhood, you would go a very big step in the legal system, which should be well considered. I'm not totally against it, but I want to discuss it for 20 years before introducing it. Then just imagine your boss is a machine. Do you really want it? Do you really want someone who is just an AI owning your company and deciding on the question to fire you or not? So that's a good question to consider if you think of e-personhood, what it means in the end. And I think it sounds like science fiction, and we should consider in more detail before we make it a reality.
Okay, thank you very much.
I thank you for this very interesting discussion. It was a real pleasure to receive your questions and insights.
Yeah. So, Dirk, who is now available for our last panel discussion? Is it still planned? Yes, I believe.
Yes.
Yeah. Okay.
It is. Well,
I will not be able to,
okay,
to attend to the discussion. I'm half an hour late for a faculty meeting.
Sorry.
So thank you very much for having me here today. It was a real pleasure.
Thank you from our side, and have a nice day.
Thank you. Bye.
Bye-bye.